Appeals versus Appellate District of Ohio with the Honorable Pierre Bergeron presiding. May I say, please proceed.
Good morning, everybody. Welcome to the First District Court of Appeals. We have 3 cases to be argued today. I'll call the 3 cases. If counsel could identify yourselves and indicate your readiness to proceed. First case is Mullins versus Mullins.
J. Stephen Cox for the plaintiff, Your Honor.
Okay.
Martin Hubble for the appellate.
Okay. Next case is State versus McDonald.
Sarah Nelson on behalf of the appellant.
Okay.
Paula Adams on behalf of the state, so I'm ready to proceed.
Okay. And then the final case is State versus Morales.
David Hoffman for the appellant, Your Honor, ready to proceed.
Okay.
Paula Adams on behalf of the state, I'm ready to proceed.
Thank you. Okay, each lawyer will have 15 minutes to argue. We'll keep track of your time at the podium. And Mr. Cox, would you like any time for rebuttal?
Yes, Your Honor. I'd like to reserve 4 minutes if I could.
Absolutely, you may. You may proceed when you're ready.
Thank you. Good morning. May it please the court, counsel Stephen Cox, again, representing the appellant Brian Mullins in this case. Your Honor, basically, this case is not a situation of a disgruntled ex-husband complaining about the way a domestic relations court dispersed marital assets in the divorce. In general, the court ordered a fair and equitable division of the parties' marital assets, and the appellant accepts the lower court's ruling with one major exception, and that is that he had a particular investment account in which the court simply got it wrong in its decision. And the appeal is about an E-Trade brokerage account, and the number is 6105-0940 and nothing more. And I'll refer to that as 0940 throughout the argument. Now, the appellee, Mrs. Mullins, would like for the court to believe this is a issue of credibility of the witness, or that it relies on a report of a financial forensic accountant that we'd hired during the case. It does not rely on that at all. The issue in this case is that
Didn't the court reject the analysis of the financial consultant?
It did in large measure, but again, what we're saying is we're not relying on that analysis or that report in this appeal.
So we don't need to consider that?
No, not at all.
Okay. So then what do we consider?
Well, the issue in the case is that the lower court's ruling was contradictory, and it's not based on the facts presented with regard to 0940, okay? The facts that are supported by the evidence and testimony of my client and the trial record shows that the facts were not contested and never brought into question. So the first assignment of error contends that the lower court contradicts itself in the decision by, on one hand, saying that the entirety of 0940 was a marital asset, while in that same decision holding that a 2019 capital gains liability incurred because of the sale of 75 shares of stock. It was MasterCard stock out of a block of 580 shares in that same account was solely appellant's responsibility because it was held to be, and I quote the judge, as a result of the sale of Mr. Mullins' separate assets.
But how is that necessarily contradictory? Because we're talking about multiple different types of stocks here. Why couldn't the court have made a conclusion that this particular group of shares was a marital or a separate asset and others were not? Because, I mean, that's in fact the analysis that you're undertaking in your brief. You're saying some are separate, some are marital.
That's correct. And if that were the case, the court under Tyra should have explained what the difference was, because it was 580 shares of MasterCard stock, and that stock, 75 shares was taken and sold by my client, actually to pay off a second mortgage on the house, and the court didn't determine why the rest of that block of stock, of MasterCard stock, should be separate. And under Tyra, the analysis that they refer to under 3105-171D is that the court shall disperse a spouse's separate property to the spouse. If it does not do that, it has to make written findings of fact to explain the factors it used to make the determination that that spouse's separate property should not be dispersed to the spouse. So it didn't do that. It just said, on one hand, we're putting all the burden of the capital gains payments on my client, and on the other hand, saying, but this is all a marital asset. So it's
Counsel, wasn't
contradictory.
it the case that all of the MasterCard stock was purchased after the date of the marriage?
It was not. It was purchased again, and I think we addressed that in our response brief. It was purchased with assets from premarital stock that was owned by my client.
Right. I understand that the tracing that you're arguing.
Right.
But the purchase, like the MasterCard stock did not come into the E-Trade account until after the marriage. Right?
It came in after the marriage, but using premarital assets. So it does not commingle, it does not lose its separate identity, and we were able to trace that back. Oracle, a couple of other stocks that were sold.
Right. So if the trial court found that the tax liability was your client's separate burden, given that MasterCard only became owned by your client after the date of the marriage, then by default your argument is that the trial court must have found that MasterCard was traceable to a separate asset.
Absolutely.
Thank you.
And I'm still confused on your point about the findings of the trial court, because in the trial court's decision, there is a specific finding that this is a marital account. And are you saying that there's not enough detail in that conclusion?
It doesn't, not to interrupt, Your Honor, but it doesn't explain the difference. In this particular case, I think, and it kind of goes with our second assignment of error, it's somewhat intertwined with the first, they're treating this account as a purely cash entity and one solid block, and saying that that's a marital asset and should be divided. But you need to understand again, and we recognize that the cash portion of that is marital and to be divided, but it also contained premarital shares of stock, which we contend to be Brian Mullen's separate asset. And you've got to look at it as like a file drawer with two separate files inside. One is purely securities, and if you don't take marital assets to either purchase or increase the value of that, it's never touched. The money going into the cash side, which is the other side of the drawer, that money goes in and goes out and is intertwined to the point where we said, okay, you can't trace that, so that's a marital asset. So the E-Trade investment account held by Mr. Mullins was opened by him before the marriage, and it's corroborated by the statements in Exhibit V and presented and accepted at trial. So the other stock holdings that we contend were separate and acquired before the marriage was Ameren Corporation, Duke Energy, Procter & Gamble, and American Electric Power. And these were all clearly shown to have been in Mr. Mullins' ownership prior to the marriage, which, again, is another fact.
So what about the point that there's an extended gap where there are no statements? Like, what do we do with that?
If you look at what has to be filed every year as far as tax filings, the 1099s, they show what purchases were made during that ensuing period, and those were also included in Exhibit V. And if you look at those as to was any stock purchased during that time or any assets used to purchase that, it shows that there's a continuous link. So by the last statement that we had, if there is a gap, the next statement would show only passive income that would increase the value of that. There were no stock purchases made other than, as I said before, taking the Oracle and some of the other stocks and purchase, and those were separate, and purchasing MasterCard stock. So again, if you look at it from that aspect and that standpoint, that we are able to at least trace or show that the 1099s would prove through Exhibit V that these, even though there is a gap, there is no discrepancy as to were purchases made or were stocks sold.
Counsel, I know there was a motion for stay that this court denied. Has the account been liquidated as of today, or what is the status of the account?
As of today, it's with Quadro Consultants or Quadro Group, and it has not been liquidated. But all the paperwork is there and waiting on them.
All right, so your client is still in full possession of the account?
He is.
Thank you.
Now, in Exhibit V, again, as I stated, this demonstrates what stock was separate and what was marital. I kind of referred to this a little earlier. There are no allegations of commingling presented in the lower court alleging any marital funds were used to purchase or increase value of these separate shares, and any gains were just through passive growth. So the shares of MasterCard stock in the brokerage account were clearly traced to the assets owned before the marriage, and we contend our husband's separate property. I think that's another fact. And again,
But how do we know that the gains were nothing but passive growth without the documentation of the statements to validate that?
again, if you look at the 1099s, it would show if money were put into that or if the stock was liquidated, and that's an annual tax filing that was included in Exhibit V. That's the backup documentation we would have. Again, from the standpoint of those missing documents, I have no idea what happened to them. So, but they are far enough back that I think the brokerage account said they could not be retrieved.
That's not controverted in this case, is it? I mean, there was no other testimony provided to suggest that this was anything other than a passive investment.
Correct. So, and again, as far as, for instance, the MasterCard stock, not only, like I said, the plaintiff did not dispute this at trial. Mrs. Mullins actually argued that stock was husband's separate property, and for that reason, she shouldn't be responsible for the capital gains. And that's in her written closing. That's TD 189, page 12.
Isn't that just as to the MasterCard stock, though?
Well, the MasterCard stock, but again, as far as being able to look at, like Procter & Gamble stock, for instance, there was an issue, I think, raised by the appellee that there was a different number of shares at the end of the marriage than there was at the beginning of the marriage. And that all has to do with stock splits. And the stock split 2-for-1, if you take the number of shares before, the number of shares after, the value of the shares before and the value after, divide them in half, it's going to be the same number, other than passive income from the growth of those shares.
But there wasn't, at trial, there was no evidence of the stock split, correct?
The stock split, I think, was testified to relative.
Other than testimony, there was no corroborating evidence.
No, but the stock split, that's public record. I mean, it shows that.
Well, isn't usually judicial notice safe for like geographical information or government information, like for example, who the president is, that sort of thing, rather than issues like stock splits?
It generally is used that way. I agree with you, but by the same token, if you look at the figures, the numbers, before the stock split and the day after, the numbers all line up. It's double the amount, half the value. So the fact that there are additional stock shares in that portfolio, the bottom line dollar figure does not vary.
What resource could we consult if we were to consider taking judicial notice of these stock splits?
There is, let me see here. ZFX, you punch up P&G stock price, history, and stock splits. It tells you exactly how many stock splits have taken place from the Procter & Gamble Corporation from 1890 until the current day, which is 6, and it shows on June 24th, 2004, the rate, it's split 2-for-1. It's, again, public knowledge, and as my niece says, you just have to goggle it.
And Mr. Cox, you are at your time if you want to reserve.
All right,
4
thank you,
minutes.
Your Honor.
Thank you. Mr. Hubble?
Good morning. May it please the court and counsel. This case is really summed up in 3 areas. Whether or not the trial court abused its discretion, the credibility of husband in this case, and the fact that this was husband's burden to prove all of this. Wife had no burden whatsoever. I'm going to start with credibility and focus on your question regarding the significance of the Flagle-Huber-Flagle report. There were only 2 people that testified regarding, or for husband, but only 2 testified regarding his accounts and his assets. The Flagle-Huber-Flagle report used some very odd accounting principles. They did not consider tracing to be important. They did not factor in commingling whatsoever. And they had this very odd manner of applying husband's marital income to, if it was put into an account, it was all his. That is not Ohio law, and the trial court was very clear in rejecting that. So how does that tie into where we are today? Husband adopted the methodology. He testified at trial that I believe in this report, I believe in its methods, I believe. So there is no one else that has testified differently. So that is why when you look at husband's case and his burden of proof, the trial court saw that there was a credibility issue, and they applied that in this case.
Well, so that makes sense for some of the issues, but when we're talking about like some of the nuance of these stock questions, what's wrong with the analysis that Mr. Cox was positing, that you look at the number of shares at the time of the marriage, and then you look and see, you know, maybe there's some splits, maybe there's some dividends that have been reinvested, but like what's wrong with that methodology?
So on the dividends specifically, no specific testimony was offered by husband at trial. I understand that if you break this up, I sort of break it up into 3 that were in the account as of August of 2003, AEP, AEE, and Duke Energy. There's a stock amount at that date, and then there is a stock amount in the closing date. That's a separate entity. If the trial court just said, you know what, husband was not credible on those issues, I don't know how else she got there. But as it relates to MasterCard, his analogy is wrong for 2 reasons. The argument is we sold 4 stocks, and those stocks were used to purchase MasterCard stock. Those 4 stocks are Sun Microsystems, Cisco, Oracle, and Pfizer. Those were sold over a period of 4 years. The reports say that they sold those for $4,300, purchased MasterCard for $3,900, roughly. The problem is that there was another stock purchase during that time in 2005 for a Dolby Laboratories for $1,100. So if you accept husband's argument in full, he purchased $5,000 of stock for $4,000. We need more money to come into the account for that to happen. There's no testimony regarding that, except if you look at Plaintiff's Exhibit 26, that shows that prior to or after 2013, that shows the number of times husband contributed money into this account. He is a person that every single check, there's some money goes to savings. He testified at trial, I did that prior to the last statement being shown. We lost statements in 2013. He said, I did that prior. We don't have the exact records. These consolidated statements that are being referenced, there is no cash account listed on any of there, anywhere. So we can't tell how much money he was depositing.
So the 4 stocks that were liquidated, is there a correlation on the dates of like the liquidation and then purchase of MasterCard stock?
There is not. The Sun Microsystems was sold in 04, Oracle 05, Cisco in 06. And so if you take those and then you commingle what husband testified to, that he was putting marital funds into that account, that is commingling. And if he doesn't provide testimony as to what he did with that account, that is the abuse of discretion. Did the magistrate have enough? Did the trial court have enough when they made this decision to say? And The answer is clearly yes. They knew how he contributed into his account. He knew that, or the magistrate knew that husband was fully on board with this flawed report. And the magistrate knew that husband operated, that he put money in and he took money out. It was constant back and forth out of this account. So if we provide that sort of use of an account to that period where we have no statements, 03 to 13, there is no way to determine whether or not this is traced to a separate asset. And to the burden.
Did he acknowledge that he was putting money into the stocks versus the cash portion of the account?
He said he was contributing. I asked him if you were contributing prior to the last statement in 2013, and the answer it was yes. So there was nothing that I saw other than just the blanket statement of the stock was purchased.
How do we reconcile what you're highlighting in terms of traceability and the difficulty with tracing the MasterCard stock in particular, given that it was purchased during the time of the marriage, with the trial court's finding that the sale of the stock in 2019 for the home to pay off the home equity loan was husband's separate property?
The trial court said two different things. I don't know how to answer your question on the sale of the taxes, other than that husband did not object to that issue. So we're not here on that one.
But you didn't object to it either, right? So how do we line those up?
Yeah, I mean, that inured to your client's benefit, that determination.
Correct. When you have 25 issues that are brought to trial and you sort of analyze, hey, what are we going to object to? Is this worth it? There were a couple things that did not go our way. Not much. I rarely had a case where we pretty much prevailed on every single account because the Huber-Flager report was relied viable for husband. But the car issue, the reconciling of daycare expenses, my thing to my client was, it's just probably
well, right. And I get that, but going back to Judge Kinsley's question, so how did the trial court find that liquidation of that stock was a separate obligation on husband's part if the stock is all marital? That's what I think we're struggling with.
I can't answer that. I don't know what the rationale was by the trial court other than, this is all speculation, but given the fact that we litigated most every issue as a result of husband's reliance on this report, the trial court has discretion to give an unequal division of marital assets and debts. We could resolve that if that was an issue on appeal, which is not. So I don't have a great answer for you. I apologize. Okay. Again, back to the issue of the credibility. This court stated as recently as the 10th of May, what is unconscionable for an abuse of discretion standard? What did the magistrate have? And if you have somebody that doesn't trace and does not believe in commingling, and we have cash in, cash out, and we can't exactly trace anything to the MasterCard stock, is that enough for the court to say, I don't think you've met your burden of proof? Husband testified two different ways at trial. He said, I didn't contribute any money into that account when we didn't have our statements. And he said, I did contribute. The magistrate is allowed, the trial court is allowed to choose which one of those to accept. The decision on the objection said it best. It's not that the magistrate got it wrong. Husband just isn't happy with the decision. And that, unfortunately, for him, is the court gets to choose.
Was there a specific finding of credibility by the magistrate or the trial court?
Just regarding the sort of unapproval of the Huber-Flager report, and that it is not so. And inherently, I think it's in there.
Well, I mean, at this point, your opposing counsel has said that we're setting that aside. We're not even asking the court to look at that report. So what are we supposed to do with that then?
I think you just use it for the overall, and that is two people testified. They both have the same beliefs as to how you're supposed to determine marital property and separate property. So if husband testifies, that is my separate asset, he is utilizing what in his mind is a separate asset, which is you ignore commingling, you ignore tracing. For the actual account itself, there was an analysis for it, but as we're here today, the specifics of the account analysis by the expert is not important. But the fundamentals of how they got there and husband's adoption of that, that is still relevant.
Can you address the judicial notice question? Is it appropriate for us to take judicial notice of these stock splits, and if so, from what source?
The first that I heard that there was a stock split on Procter & Gamble was in a reply brief. It was not testified to. There were 50 shares, I think, at the time, and all of a sudden we have 100. I don't know that it's appropriate because there was no testimony by husband as to what happened specifically to Procter & Gamble from 2003 until 2013, when we started having statements again. So if you're taking judicial notice, I think you are applying that there was no change in this account anywhere. And I don't think we can do that. I think judicial notice is something that's not disputable. And I think there is a dispute.
If indeed, I mean, let's back into this. If indeed Procter & Gamble had a stock split, is that the kind of thing that would be disputed in a trial? Would you have brought in testimony to say, no, Procter & Gamble did not have a stock split?
I wouldn't. I think we would go back to what happened to Procter & Gamble after that stock split. I think the claim is that in the early 2000s there was a stock split. I can't tell you, and husband didn't testify as to what happened to that Procter & Gamble stock after that. So is that meeting your burden? By just saying there was a stock split out there somewhere on stock that I can show in August, I just didn't tell you what it did for the next 10 years.
So either there was or there wasn't a stock split, but for us, we need to look at the statements and see what happened in this account.
Since there are no statements and these consolidated accounts are incredibly limited, I don't know that we can tell because husband didn't testify to it.
Thank you.
Regarding the condition of the account, I just want to address this on the last assignment of error. I'm not exactly sure what that assignment of error is, but I want to say that it has been my position that when that account gets divided, you're going to divide everything, the tax consequences. If you have 10 shares of MasterCard that have a tax basis of X, they can do it now where they divide half a share if they needed to. And that is the process that we're going through now to divide all of that. So I do not believe that is an issue. I have offered that to Mr. Cox, and I think we are moving forward on that.
And do you agree with Mr. Cox's representation about the current status that you're awaiting Quadro?
Correct.
Thanks.
Correct. That is in process now. And to the issue on Procter & Gamble, where there was a stock split from 50 shares to 100 shares at some point. In Exhibit V, page 62, there were 130 shares of Procter & Gamble. There are now 100. I do not know how we got to 130. There was never any testimony. There was never any argument. And that just goes back to what husband's burden is. There was a quote in husband's brief. It says, to that point, meaning when MasterCard was purchased, no additional funds had been contributed to the brokerage account. There are multiple statements in the brief referencing that. And on none of those statements is there a citation, because it does not exist in the record as we have it. On behalf of the wife and the appellee, I am requesting that the court affirm the trial court in full. Thank you.
Thank you, Mr. Hull. Mr. Cox, you have 4 minutes of rebuttal.
With reference, and we didn't get to that before I ran out of time, to the final assignment of error. The final assignment of error points out that the decision needs at minimum to specify that the stock holdings that we agree are marital or you order are marital are not to be converted into cash before distribution, because that would trigger a capital gains tax on my client only. The problem is that the court speaks through its entries. It's not a problem, but in this particular case, it's the decree. We can't assume they meant equally divide the stocks and then the cash portion, divide that in half or whatever, when they give a specific dollar figure saying she is to receive X number of dollars on an account that's worth this. In order for that to happen, somebody has to pay capital gains on sale of that stock. So we urge the court to specifically hold what shares of stock are marital and divide those shares, or have the court, the lower court, say, yes, that's what we meant to do. We can't assume that's what they meant to do. They said this was worth $178,488, and it's a marital asset. Again, ignoring all the order that was previously issued that said part of that was husband's separate asset altogether, because he was the one that had to pay for the capital gains in 2019. Mr. Hubble continues to say that the money has gone into this account again, and we can't tell where it went. Again, you've got to look at it as a drawer with two file drawers, one cash and one securities. And the 1099s would show if any additional securities were purchased, which they weren't. As far as the stock splits go, you look at the number the day before the stock split happened, the day after, you've got double the amount of stock and they're worth half.
Did your client testify about the P&G stock split?
Pardon me?
Did your client testify about the P&G stock split?
He did not, because it wasn't raised as an issue.
Well, but, I mean, if you all didn't address that with evidence at trial, how are we supposed to consider that on appeal?
Again, from our standpoint, it's judicial notice. It's a public record that that's what happened. You look at the value of the stock now and at the time of the split and the day after.
Yeah,
it's
but I
the
mean,
same number.
I think it's one thing to say judicial notice, but it's another thing at trial to not raise that issue and not allow opposing counsel to explore that, and then, like on appeal, say, hey, there's a stock split.
If it was not raised at trial and everybody agreed these number of shares were husband's premarital assets, which the testimony was that he owned P&G prior to the marriage, it wasn't raised as an issue as to why this number is different than the other, so we just went with it.
Was it briefed or somehow put before the trial court?
I do not recall that happening. So again, it's our position that there's no change in the P&G account. The court, again, has the ability to do an unequal distribution of marital assets, but they need to explain why under TIRA. And they did not do that, and that's why we have the issue as to if it was deemed to be husband's separate asset and he was exclusively responsible, and we're talking about the MasterCard stock, he was exclusively responsible for capital gains, why isn't the balance of that account 505 shares, why isn't that separate as well? So with that, we would ask the court to rule that there was clearly abuse of discretion and reverse as to the arguments made.
Great. Thank you. Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision, and hope you both have a great day.
Thank you.
All right, the next case is State versus McDonald. Ms. Nelson, how much time would you like for rebuttal?
5 minutes for rebuttal, please.
Sure. You may proceed when you're ready.
Good morning, Your Honors, and may it please the Court, and good morning, Ms. Adams. Sarah Nelson again, here on behalf of the appellant, Mr. Robert McDonald. Your Honors, this is an exceptional case where the evidence does weigh heavily against a conviction. A person is entitled to use self-defense within their own home, and affirming a conviction in this case would create a manifest miscarriage of justice and undermine the Castle Doctrine.
Ms. Nelson, was there any argument at the trial court level about defense of another rather than self-defense?
No, Your Honor.
Thank you.
This was squarely a use of force in self-defense. I know that the facts sort of suggest defense of home, defense of others, but the action in this case took place when the threat of harm was directed specifically at Mr. McDonald. So this is squarely a use of force in self-defense.
What was that threat of harm?
The aggressive approach into the apartment creates a hostile environment. Once that hostility is the person, the decedent, Mr. D'Angelo, when the threat of harm is projected towards Mr. McDonald the moment where he turns and step towards, charges at Mr. McDonald. That's the threat, the threatening body language, the threatening action. Once it's turned toward Mr. McDonald, that's where the threat of harm is redirected at him.
But how do we know that that threat of harm was of death or serious bodily harm?
Under the circumstances of this case, we look at the total picture, what's happening in the moment that the use of force is employed. Mm-hmm. I'm sorry, can you repeat your question?
Yeah, I mean, so he doesn't have a weapon, the victim does not have a weapon. There's no indication that he didn't say anything like, I'm going to kill you, or something that would suggest a threat of serious bodily harm or death. And I guess my question is, under how you're envisioning self-defense doctrine and the Castle Doctrine, can simply a physical attack of some sort automatically justify the use of deadly force?
I think under the circumstances of this case, when the violent conduct occurs within a home where a person has the right to be and can use force in self-defense in the home, then those factors, they do tip in favor of Mr. McDonald to the extent that there's some conflict or suggestion that it wasn't as aggressive as it seems. That just brings the scale back into balance. It doesn't tip it down to beyond reasonable doubt, and that's kind of where I think the facts in this case do indeed support the affirmative defense of self-defense. The couple of things the facts that you're describing to me speak directly to I think the only contested element in this case, which is the reasonable belief of serious bodily harm. I think there are several facts that go to the objective belief and the subjective belief. And if the court will indulge me, I'll go through why I think that those matter, or how they're met in this case. On the objective prong, knowledge of a person's history of violence is relevant to that analysis, and this court noted that in State v. Rawls. We know that Mr. McDonald in this case was aware of D'Angelo's violent history, his violent actions toward Lanisha, and that he had threatened harm against Mr. McDonald himself.
But didn't Mr. McDonald say that he didn't take that seriously?
At the time, I think that's what he was referring to when the threat was first conveyed, but that doesn't undermine the fact that the threat was conveyed. Not only that, but he is still aware that D'Angelo was violent to Lanisha, the person who he breaks into this apartment to aggressively approach and threaten with harm. He says I should beat you, I'm going to beat you. That's the language he's using in these events. So I think under the totality of the circumstances, objectively, there is knowledge of propensity for violence and a knowledge of a prior threat of harm. The comment about not being concerned about it at the time perhaps brings the scale that's already tipped in Mr. McDonald's favor back into balance a little bit, but there are two other factors, objective factors, that I think keep the scale in Mr. McDonald's favor, which are the forceful entry, like I already mentioned. He kicked the door once, didn't open, kicked it twice to break into the apartment. That is a significantly violent action that someone's taking to break into the apartment to confront somebody. This isn't a situation where,
But again, not to confront him, it was to confront the girlfriend.
sure, but again, when we're using force in self-defense of the home,
Well, but that gets back to Judge Bach's question at the outset. Was there any sort of defensive other type argument?
oh, I see. No, and again, I don't think that this record supports that at all. But I don't think that takes away the objective facts in this case that are basically undisputed, that there was a violent entry into this home.
But Mr. McDonald didn't react in self-defense when the door was kicked in. He reacted minutes, it seems like, later. I don't know that any witness described the time period, but there were certainly more interactions and conversations that occurred after the door was kicked in. So how is the door incident relevant to the self-defense issue at all?
Well, it's relevant to the circumstances because the objective prong considers what's happening in totality at the time of the event. So it's not, I would push back on it being minutes. I think that this action occurred much faster than that. So it's escalating quickly, and when he's approaching the girlfriend, Lanisha, she says, go fight him. He's directing his aggression toward Mr. McDonald. So this violent behavior that Mr. McDonald's witnessing is going toward one person, and then within the matter of seconds, I believe, gets turned on to him. Those circumstances in the home setting support an objective belief of serious physical harm. Most of that is unrefuted, the violent activity, the breaking into the apartment, the fact that Robert was aware of the violence and the prior threats. Regarding the subjective belief of harm, I think there are two significant facts going to that component of the reasonableness. The perception of choking and the perception of being charged at. We're talking about subjective belief, and even though there are two witnesses in this case who testify in ways that are different than Robert's perception, that doesn't make his subjective belief one that's unreasonable.
But let's talk about that. I mean, like if the defendant says, I had this subjective belief and here's what it was based on, and two other witnesses, and I'm not saying this is exactly what happened here, said that's not what happened at all. In other words, they're rejecting his factual recitation of what happened, then doesn't that, I mean, that creates more of a jury question as to who to believe in that scenario, right?
I would say in terms of weighing the evidence, we have two witnesses who say choking and charging. That's Tamara and Robert. We have two witnesses, Latoya and Lanisha, who say no choking, no charging, right? That's not flipping the evidence so heavily in favor of the state or negating beyond a reasonable doubt that Mr. McDonald used force in self-defense. Again, it brings the factual situation into balance here because we're dealing with the presumption in favor of self-defense.
But that gets into credibility determinations, correct?
Well, interesting question. Normally I would say, well, yes, it does come down to credibility determinations, but we don't have any expressed factual findings in this case by the trial court as to which witness he believed on which fact. And this court gets to review the evidence and reweigh it. It's not credibility in the sense that we defer to a credibility finding because there is no express finding. That's something that's just distinguishable between this case and State v. Rawls. And I keep relying on that case because I think that there are two significant distinguishing factors. One, the lack of express finding of credibility on any fact. In Rawls, the trial court expressly found that the defendant's story lacked credibility. We have a state's witness who's corroborating some of Mr. McDonald's story in this case. So which witness did the trial court believe? Which facts did he specifically rely on? We're not exactly sure. The second thing that's distinguishable and interesting about the Rawls case as compared to this case is the fact that there was, sorry, I'm lost in my notes. The duty to retreat. Although it's not at issue in this case, the trial court noted that the defendant could have brandished the gun in a way to sort of mitigate the interaction between the decedent and the defendant, could have done this, and he says this finding in the sense of there was a duty to retreat, you should have retreated, this is what you could have done. Robert did that in this case. He acknowledges that he was holding his gun, and LaToya Adams testified that he had the gun out. D'Angelo charged at him even though he saw the gun. Robert's statement to the police...
Do we know he saw the gun?
Well, that's what Robert told the police during his statement, his post-arrest, or his interview that was submitted into evidence in this case. He acknowledges that he had his gun out and that D'Angelo saw it. I think that fact is significant when we're talking about perception of harm, whether or not it's objectively or subjectively reasonable. If somebody's charging at you while you're holding or you're in possession of a firearm, that creates a different heightened threat, particularly one in the home where you're entitled to use self-defense, and there's a presumption weighing the evidence more favorably for the person using self-defense. I don't think that the state's evidence in this case brought the scale back into balance, but I know that I'm dealing with the trial court's finding of guilt in this case. I don't think it brought the scale to prove beyond a reasonable doubt that Mr. McDonald did not act in self-defense.
On the question of the home, I mean, this wasn't his home. In fact, at various points in time, it had been Mr. McDonald's home, or both of these men had stayed in this particular apartment, right?
Well, at the time of the event, this was where Mr. McDonald was staying. He had stayed there the night before. He had been staying there with Lanisha. The decedent had not been there at the time of this event. The parties had split. Lanisha and D'Angelo had split about a month before, or within the month preceding these events. So no longer was this his home where the decedent had a right to be, but as an overnight guest, certainly as an overnight guest, Mr. McDonald had a right to be there and therefore was entitled to use self-defense.
Ms. Nelson, does it matter that the defendant did not testify in this case? Does that make a difference to his claim of self-defense? Because, yes, there was the interview, but that wasn't under oath.
I understand, Your Honor. There was no contest to the admission of his statement as being evidence. So on this record, I believe that the evidence is accepted as credible evidence. There's no argument to be made here that it lacked credibility because of it was not being sworn under oath. I understand when there's self-defense cases and the defendant does not testify that is a significant thing, but we do have a defendant's statement in this case. And I think that that's relevant and important to the analysis.
All right, thank you, Ms. Nelson.
Thank you.
You're at your time. Ms. Adams?
Good morning.
Good morning.
May it please the court. Ms. Nelson. The state's first point we wanted to make goes to the point that Judge Kensley made, that there's a strong argument to be made here that Mr. McDonald, this cannot use the Castle Doctrine because the testimony that was provided by the individual who was full-time in the apartment, Ms. Walker, she did testify that Mr. Amundsen had been living in that residence with her and their children, the children that they shared on and off at the time of the shooting. So there is a strong argument to be made that that presumption of defensive residence really isn't even applicable in this scenario to Mr. McDonald. With regard to the second issue that the state sets forth goes to a point that Judge Bergeron made, and this is that really whether or not Mr. McDonald felt that he was in imminent danger of death or great bodily harm, it really does boil down to credibility in this case, and that was the trier of fact's duty to weigh that. And in this scenario, which again, Judge Bach had brought that point up, is that the only information that we have from the defendant came from that statement to the police, and that wasn't under oath. So I think under certainly the facts under subjective or not, that the information that the trier of fact had to judge before it and weigh that credibility weighed strongly in favor against self-defense.
If there is a threat of physical attack and the victim does not have any sort of weapon, is that sufficient to trigger self-defense by use of deadly force? In other words, like take this scenario where there is, it looks like there's going to be a physical assault of some sort. We don't know what that assault's going to look like. We don't know if it's going to be some shoving. We don't know if, if this guy's an MMA fighter and can do some real damage. And the defendant shoots the individual. Like, how does that square with how Ohio law on self-defense has evolved?
Well, and again, all we have from the statute is that they have a bona fide belief that he or she is in imminent danger of death or great bodily harm, and that his only means of escape from such danger was the use of such force. So certainly that it's very fact intensive, and that's what the trier of facts duty to do is to weigh that. And I think there's no getting around looking at the facts and the credibility. And this case is completely about credibility in that regard. So certainly, and again, yeah, when someone thinks that they're going to have things are going to fisticuffs, you don't, expect that to be shot point blank in the chest, and that's, what we have that occurred here. Certainly, we don't think that you should even have the presumption, but two, even if the presumption were applied here, that there is certainly does not rise to the imminent threat.
So one thing I've really been struggling with since the change in the law, so the second element is the bona fide belief that he was in imminent danger of death or great bodily harm, and the only means of escape from the danger is the use of force. But then with the Castle Doctrine, there is no duty to retreat, correct?
Correct.
Okay, so does that have to be their only means of escape now?
I mean, that's a good question. I think that, again, I think it's hard to take the analysis away from the facts in the case and what escape can mean. What does that mean, getting completely out of the residence at that moment, or just taking yourself out of the affray? Because as Judge Bergeron pointed out, or maybe it was Judge Kinsley, I'm having trouble following he didn't go in there, he didn't kick in the door with having a beef with Mr. McDonald. Mr. Amundsen went in, this was supposed to be an exchange of the child and the supplies for the child. And
let's change the facts a little bit and say that McDonald and his girlfriend are sitting in the apartment, and all of a sudden the victim kicks in the door and he shoots him upon kicking in the door. So, would that be justified from a self-defense perspective?
It might be a little closer, but again, having I guess you're going to need more of the outlying facts.
Well, I mean,
if it's just a stranger thing and he,
well,
kicks
right,
in the door, he would
if-
have a stronger argument, yes. But again, it's hard to take credibility out of the equation. I don't think you can, and that's why I think in Messenger, the Supreme Court told us that it's a manifest weight analysis that the reviewing courts are to undertake in this regard.
Do you dispute that it appeared that this was headed for some kind of physical altercation?
I think when you look at, and it's hard, to take the personalities and the characteristics of the people out, the fact that the words and the wording that was being used and was being exchanged, and I think you even have a little bit of Ms. Walker maybe taunting, egging it on, trying to get, the two to fight between each other. I certainly think that there's a little bit of that, but I certainly, under these scenarios, or the scenario that we have here, I don't think that anyone expected a shot to be fired. Definitely. Unless there's any further questions, I will submit.
Great. Thank you.
Thank you.
Ms. Nelson, you have 5 minutes.
Thank you. The state argues today in its brief that at or around the time of the incident, and we talked about this previously, Judge Kingsley, that D'Angelo was staying with Alicia, and I think the record completely refutes any sort of claim that that D'Angelo had some right to be on the premises on the date of this incident. That is not supported by the record. The state did not argue that below. Regarding the statement, the fact that it wasn't, Mr. McDonald's statement, the fact that it wasn't presented under oath, the state could have objected to the admission of the police interview, but they didn't. It was accepted. State could have insisted on in-person testimony if they had any sort of concern over the credibility of this statement. So as far as the statement taking place out of court, but with the police, I still think that gets some weight by this court, and it doesn't just get dismissed as lack of credible.
Might there be other reasons for the state to not object to that video's admission? I mean, for example, the fact that he said on the video that he didn't take the previous threat seriously. I mean, that works in favor of the state. So its admission isn't necessarily because the state is conceding that that he is telling the truth or that it's credible, correct?
Certainly, they're not actively conceding credibility of the statement, but to the extent of this court being able to consider it as being a credible statement, it certainly can, I guess is my point. Just because it was taken out of court doesn't all of a sudden make it lacking in credibility. And if the state had any concern about the facts that do affirmatively support Mr. McDonald's position, that's, I think, the situation where I'm coming from, where the state could have objected to this, because there are several instances in his statement where he's supporting the subjective belief of imminent danger, imminent bodily harm. And we have to accept those statements in this case as facts.
Well, from an evidentiary standpoint, it's the only piece of evidence that we have as to what might have actually been in Mr. McDonald's mind.
Correct. I will say, though, that it was corroborated in certain important respects by Tamara, and we don't have any indication on this court that the trial court expressly found Tamara to lack in credibility. So if this court does want to discount Mr. Roberts' story for any reason because of the fact that it was given on the video and not in court, we still have Tamara supporting what he says, and that's a state's witness. In my view, I think the state is advocating for a wait-and-see approach, and you can only shoot if there's a weapon brandished when the encounter occurs in your own home. That's the sense that I get. It sort of ties into the scenario that you offered, Judge Bergeron, about if a stranger opens the door, in that moment as a homeowner or somebody who's entitled to be in a residence, do you have to wait to see if that person's going to pull out a firearm before you can act against that person? They're breaking into your home. Do you have to, can you only shoot in that scenario if somebody, again, threatens, makes a verbal threat? That's a threatening act in and of itself to break into somebody's home. Aggravated burglary is an offense of violence. It's not something that we take lightly under the law, and that's what's happening in this case. I think that this case actually is more of a close case as it comes to the rebuttable presumption, but it's not close in any way to negating self-defense beyond a reasonable doubt. Again, it's different from Rawls, which this court expressly state was not an exceptional case. I think that the fact that this case occurred in the home, it presents a narrow issue, specifically really narrow with respect to the subjective belief of harm, because there's uncontested evidence going to the objective component. So again, distinguishable from Rawls, which this court said was not an exceptional case. I think this is an exceptional case. A narrow issue on the subjective belief of harm, where we have no express factual findings by the trial court negating or telling us what it specifically found was credible in this case. And finally, with the presumption of self-defense, the weight of evidence is already tipped in Mr. McDonald's favor. And again, the state's evidence did not tip the scale so dramatically to outweigh his affirmative defense of self-defense in the home. If there are no further questions, I respectfully request that this court reverse and grant Mr. McDonald a new trial.
Great, thank you.
Thank you.
Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision, and I hope you have a great day. The next case is State versus Morales. Morning, Mr. Hoffman.
Morning, Your Honor.
How much time would you like for rebuttal?
5 minutes for rebuttal.
Sure. You may proceed when you're ready.
Thank you. May it please the court, Ms. Adams. This is an appeal from a restitution order. In 29/29/18, a trial court is authorized to order restitution as a sanction. The restitution must be made to the victim of the offense. And in this case, Mr. Morales is arguing that Christopher Walker, the person that was awarded the restitution in this case, is not properly a victim for purposes of that restitution statute. Mr. Morales.
How does Marcy's Law change the analysis here?
Well,
Because Marcy's Law greatly expanded the definition of what a victim is, correct?
Correct.
Okay.
That's constitutional, which prevails over a statute.
It would, yes, yeah. Well, just to get to the point here, I'm taking the position that the Article 1 definition in Marcy's Law, the constitutional definition, doesn't apply because I'm arguing that it's not self-executing. I know it says on its face it's self-executing, but I'm taking the position that you can't democratically determine whether something's self-executing. The fact that over 51% of the voters in Ohio voted that it's self-executing doesn't make it that way. It's a judicial determination. There's tests involved. In Marcy's Law, the constitutional provision doesn't meet that test. So that's the gist of what I'm arguing.
So, counsel, do you then concede that if the Article 1 definition of victim applies, that Mr. Walker is part of it, falls within it?
That's correct, yes. After the briefing in this case, the General Assembly, or House Bill 343, became effective in April of this year. And that bill was actually, I think it's fairly considered enabling legislation that changed the statutes in the criminal code to allow the enforcement of Marcy's Law, the constitutional part of it. The provisions, the constitutional provisions are general. They don't provide fixed guidelines for equal enforcement or consistent enforcement. That legislation was enabling legislation, which is additional evidence that the constitutional provision was not self-executing. But at any rate.
Counsel, let me ask you about the specific charges in this case. So I know that Mr. Morales was charged with aggravated vehicular assault. There were 2 identified passengers who suffered serious physical injuries in this case, in addition to Mr. Walker, the driver, who apparently was not physically harmed, although his car, I understand, was seriously damaged.
Totaled, yes.
Yes. In looking at the specific provision of the aggravated vehicular assault statute that Mr. Morales was convicted of, that statute incorporates OVI as an underlying predicate offense. Mm-hmm. Would that OVI not make Mr. Walker a victim, given that it's a traffic offense?
No, because the essential element of aggravated vehicular assault is physical harm to a person based upon the conduct. The OVI element, I think, would have to do with recklessness or culpability and not so much the aspect of victimhood. But Mr. Walker was not named in that indictment. He didn't appear in that indictment. The people that were injured in the accident, they were the victims. They were the ones named in that indictment. And that is part of the test, even the constitutional test for being a victim. That being named in the charging instrument is a big thing.
So obviously, from a factual standpoint, Mr. Walker's car was damaged because of this accident involving Mr. Morales.
Correct.
And so if the state wanted to directly include the damage to Mr. Walker's car, what should they have charged him with? What would directly include that?
Well, I'm not sure, Judge. I'm not sure I can answer that question. I don't know. But
Well, if he's driving under the influence, say, and let's take the other two victims out of it, and it's just Mr. Walker, and there's the crash that's the product of drugs or alcohol, isn't that the way that the state would say, you're charged with this offense and you caused this damage to the car?
Well, the position I'm taking is that under former 2930-01H, which is the former statutory definition, he wouldn't be considered a victim because in addition to being named in the accident report or named in the charge, you have to have physical harm that requiring medical attention to be a victim. And so, no, it wouldn't work. Former 2930-01H, which is the former statutory definition, was in effect at the time of the accident in this case, which was July 25th, 2001. The amendments I mentioned earlier, the House Bill 343, which changed that definition to make it coincide with the Article I definition, didn't happen until after this was all, even in the briefing in this case, it didn't happen. And it can't apply to my client. This is a restitution is a sanction that's imposed, and the state of the law at the time of the commission of the offense needs to be used under Revised Code 1.58. And so because of that, I'm asking this court to find that that former statutory provision applies and that its strict definition of being a victim doesn't apply to Mr. Walker. And therefore, I'm asking that this court reverse the restitution order and remand for further proceedings.
Great.
Thank you.
Ms. Adams, welcome back.
Thank you. 2 points to this argument as well. First off, what this court has already brought forth was the argument that the state made that the underlying OVI certainly encompasses the property that was damaged here. And that,
yeah, I
in this
seem to
case,
recall, when Mr. Hoffman was saying that, I seem to recall a case where we had recently where the car hit like someone's house.
Correct.
And so there was no physical harm, but they obviously damaged the house, and that was an appropriate basis for restitution.
And I was trying to look in the paperwork to see if there was perhaps an OVI that had been like in municipal court, and I apologize that I don't have that information, but sometimes that happens. But in this scenario, I don't think it matters. Really, the bottom line here is what they're trying to, what defense is trying to do is to say, to pigeonhole the definition of victim as someone who's included in the indictment. And I don't think, even without the Marcy's Law constitutional amendment, I think we have a strong argument to make here just because of the nature of this particular aggravated vehicular assault. The fact that it occurred under the auspices of an OVI, that's going to cover anyone who is harmed by that, whether that be another car, a house, a tree, that happens all the time in OVI cases, that restitution's ordered for the damage that is caused, not necessarily the physical aspect, and that's why the charge is aggravated vehicular assault.
Is Mr. Walker referenced in the police report in this case?
The police report?
Yes.
Yes. And certainly in the victim impact statement, there's more information pertaining the exact damage. And I think that was the argument that the trial prosecutor had made below, was that, that all of that information was available in the fact that he was, a victim of the OVI. The second point the state
Before you go on, in your brief, did you argue that the underlying OVI was enough to, under the statute, if Marcy's Law doesn't apply? Did you argue that the OVI would have?
No, that was the trial prosecutor made that, because the timing of the new Marcy's Law stuff going into effect, that wasn't in effect during when they were arguing restitution below. I think that the constitutional provision was, but I think that was an alternative argument that was presented to the court. But certainly the constitutional amendment was something that had been relied on throughout. And it was just this past April, just just over a month ago, that the statute went into effect. But I think, given that, certainly the constitutional provision covers anyone who's proximately harmed.
Well, but what about Mr. Hoffman's point that the whole reason you have the statute is to implement the Constitution, and it's not self-executing?
Well, and I think the Supreme Court's reliance upon the constitutional provision certainly gives this court enough authority to do the same, and that was in Allen that the Supreme Court had already looked to the constitutional definition of a victim, if you will, in its analysis, and so I think that is certainly sufficient authority. So safe to go on to my second point now, is that the amount of restitution was not raised below, so I don't think that that's something that should be considered by this court. Unless there's any further questions, I will submit.
Great. Thank you. Mr. Hoffman?
State versus Allen held that my former statutory definition of victim was limited to use within Chapter 2930. And it based that conclusion just upon some language at the beginning of the definition section itself in 2930.01. It said, as used in this chapter, and then it goes on with the definitions. And that was basically the basis of Allen's holding. Now, after these April amendments, I checked, and although the bill did change the definition of victim to coincide with the constitutional, the Article 1 definition, it left that language, as used in this chapter. But yet it implemented Marcy's Law, which changed a lot of the revised code, the criminal code, and it effectively made that definition apply outside of Chapter 2930. And I think that the General Assembly, in effect, said that language, as used in this chapter, does not limit that definition to 2930. So I think Allen, based upon these new developments, should not be relied upon. I think that language was a frail reed to lean on. So I'd ask that this court would.
Is Mr. Walker referenced in the police report in this case?
Yeah, it was an accident report, Your Honor. In the record, it's attached to the victim impact statement. And he is he's mentioned in it, and Mr. Morales is identified as the person in error. But I want to emphasize that that accident report does not charge an offense. And so being listed in the accident report under at least this former definition former statutory definition of being a victim, that wouldn't be enough to meet the requirements for being a victim. So if there are no further questions, I'd ask that the court would reverse. Thank you.
Thank you. Thank you both for your arguments today. The case will be submitted. We'll get out kind of written decision, and hope you both have a great day.
Thank you.